This is not Alan Gassman, and this is not some of my favorite estate plans. I have no favorite estate plans, nor do I have an estate plan for myself. But if I was going to get an estate plan, I would probably call LegalZoom instead of these lawyer types. I don't know, they just can give me the creeps. Anyway, as far as what you need to know with respect to this presentation, not much, because the presenter doesn't know much. Ooh, there he went. It's coming soon. Please note that you do have his email address, Alan Gassman, agassman@gassmanpa.com. If you have any questions, then you can go ahead and send them to that email address. And there's also a question panel that you will see on the little rectangular difficult thing to understand. And if you click on the triangle, that will open up the questions, and you can type in a question like, who in the heck is that dummy, and what is he talking about? This presentation does not qualify for continuing education credit. As we've said in the past, it's simply not good enough to qualify for continuing education credit, and it's just not accredited. This presentation will go for 1 cubic hour. That's a cubic hour as opposed to a metric hour. And when it's over, shortly after it's over, you will get an email inviting you to invest in a Nigerian mining arrangement. Don't click on that one, but then there will be another one with a replay of this webinar, which you can forward to anyone you don't like and see if they want to waste an hour of their time also. Special thanks today to our IT coordinator, Peter Hopwood, and we wish Kelly the very best in her recovery from an alleged cold. She's probably actually at the beach. That's where I'm heading after this silly show. So, in just a moment, Alan Gassman, Brendan Ketron will not be here today. He has better things to do as well. Thank you. Okay, here we are, our first estate planning webinar in 2022. Thank you so much for joining. Please do send us your questions, comments, and suggestions. We've got the email address. Already I've got some questions. Are there materials to download? Sorry, none, but we will be emailing you a copy of a recent article that we placed in the Limeberg system late December called The Biden Third Step, What Do You Do with a Promissory Note? And I'll be talking about a few of those alternatives today when we talk about my favorite estate plans. And then secondly, will we get a copy of your slides? Yes, Stephen, I believe there's a way for the slides to actually be downloaded. If you go to, I'm not sure where to go. We'll email everyone copies of the slides. Kelsey is under the weather today or at the beach, depending upon whether she's really under the weather, but she's got a gravelly voice, if that helps anything. Maybe that's because she was drinking beer last night and singing really, really loud karaoke. I'm not sure. Okay. I will, at the end of the presentation, probably show you some estate view software moves. For those of you who are interested in estate view software, it is half decent now and hopefully getting better. I also will make sure that you have some spreadsheets that you can use. We have updated our spreadsheets for 2022, and I'll be showing those to you as well in just a few minutes, assuming that I can find them on my screen, and show you a little bit about the estate tax today. So enough of the shameless self-promotion. This morning I went through a few slides that we've given in the past. Wanted to thank Jerry Hesh for joining us in November of 2014 at Notre Dame University for a mathematics talk. And one of my favorite movies is Donald Duck in Mathematics Land. Hopefully Disney World will not sue me for having a picture of Donald Duck on the screen, but you can go to the YouTube and watch the 1959 Donald Duck in Mathematic Land, one of my favorite cartoons when I was growing up. And when you click on it on YouTube, Disney World will, or Disney Corporation will actually make a little bit of money, which I understand they need. Now, one thing I wanted to mention is my favorite estate plans always have plenty of cash on hand to deal with the unexpected. And I don't know, when you did your New Year's resolutions, did you budget for problems? I used to really worry about every single problem that was unexpected and cost money for our office until I set up a $100,000 a year budget for problems. And I'm just so happy if we don't hit the whole budget. But on the other hand, when people die, the cash is often a problem. It's a concern. It might be a psychological concern. It might be a practical concern. So when I sit down and talk to a client about estate planning, I want to know about how much it costs to buy term life insurance, because if the client is going to need life insurance, I would like to help them make a tentative decision during the call. So if this client is a 35-year-old physician, just got done with her fellowship, she's supporting 2 young children, and maybe a significant other or spouse who is not self-supporting and does not have enough life insurance. Well, if she or he is in fairly standard health, not even preferred, and would like a 20-year term policy for $10 million so that on death, her family will be much less sad, then I can multiply $945 by 10, that's $94.50 a year, and she could have $10 million of 20-year term. If she only needs 3 years of 20 years term, at 20, then at 945 times 3, that's about $3,000 a year. So she can walk out the door and say, boy, I think that based on what Alan and I discussed, I would like to have $3 million of life insurance. I think it's probably going to cost $3,000 a year or less. I'm going to go do that. So part of my favorite estate plan is that the things get done. So I can introduce her if I want to, if I dare to a good life insurance agent, and maybe one that just handles stuff by the phone and gets it done. They're going to have to send a nurse or paramedic over to the client's house or office at the time of their choice to get a free physical. They're going to collect the last 5 years of medical records, and 8 to 10 weeks later, you're going to get the actual rates. And I like agents who will run informal applications, not formal applications. And the reason for that is that if you go and file a formal application and you get an improper blip on that EKG or a little bit of marijuana in that blood work, then oops, that is now published to the Bureau. And I believe that every insurance company for the next 8 years that looks at an application from this client is going to see what went to the Bureau. On the other hand, if you use an informal application, it only goes to the one carrier. They don't publish it to the Bureau until the policy is accepted by the client or the client allows that. So if the client is 50 years old, which I used to think was really old, and now I think it's really young, and the client has a $3 million investment portfolio and would like to be able to provide $200,000 a year on death to the family. Well, $3 million times 4%, which is a fairly common standard, 4% of 3 million is 120,000 a year. He would like to provide his family with 300,000 a year. So guess what? He's short $2 million. So a 15-year term at $2,805 a year, or if he's in preferred health, $1,785 a year times 2, $3,400 a year would get that family another up to the $3 million a year of projected income after death. But oops, there's $1 million owed on the mortgage. Let's get another 1785. The client makes contact with an insurance agent. The insurance agent offers these term rates and says, you could go permanent. Do you want to go permanent? Maybe the client does, maybe the client doesn't. I just want to make sure that the right death benefit gets put into place. You're welcome to use these charts, or you can send an email to your favorite insurance agent before the client meeting, and they can provide you with specific rates for someone that age. So one of my favorite estate plans, fully insured. And you can put that life insurance in an irrevocable life insurance trust if you want to make sure that it's protected from creditors, if you live in a state that doesn't protect life insurance, and if you want to make sure that you do not pay estate tax on the life insurance. If the client owns the policy or has what they call incidents of ownership over the policy, then it will be in the client's name for estate tax purposes. The other thing that I like to do in my favorite estate plans is to use Excel spreadsheets and calculations whenever I can. How do you use Excel? You must meet a 14-year-old, and then the 14-year-old can put a column by column program for you, and then at the end of the day, your Excel spreadsheet will work beautifully. Somebody over than 14 also can usually use Excel, but somebody like me, age 62, I never learned it, but I'm a big user and fan of calculations, as we will show you. Now, my favorite revocable trust estate plan is right here on page 23 of the PowerPoint that we forgot to send you. And on the left-hand side, I have an irrevocable life insurance trust. This irrevocable life insurance trust can own the life insurance policy on the client's life. And if it owns that policy from inception, or if it owns the policy more than 3 years before the client dies, then it will not be subject to estate tax. The trust can benefit the spouse and descendants of that marriage, depending upon how the trust is drafted. And on the second death, the trust will not be subject to federal estate tax. So many clients who are in the $5 to $7 million net worth range also have $3 to $4 million of life insurance. And it is not in a life insurance trust. It is owned by the insured spouse and payable to his or her revocable trust on death, in which case it will use part of his or her $12,060,000 exemption. Now, even though this client that I'm discussing, this hypothetical client, is under $12,060,000 and well under $24,120,000, consider the life insurance trust if their estate is likely to grow, or you believe that the estate tax exemption is likely to come down. It is somewhat likely to come down. It is scheduled to come down January 1st, 2026 to 1/2 of its inflation adjusted amount. So there's a decent chance that on January 1st, 2026, this couple will wake up from their wonderful New Year's celebration and say, wow, our exemptions just went down from about $12,500,000 each to $6,250,000 each. We need to go get a life insurance trust more than 3 years before each of us dies as insured. So my favorite estate plan looked a little bit more in advance and also took into account the Brandon Ketron time value of money rule, which basically is if you have a 7.2% after-tax rate of return, the assets are going to double in value every 10 years. So it's easy to sit down with a client who's in their 60s and say, how's your portfolio done? Great, we did 22% last year. Okay, super, it's at 6%, it's at 6 million. What do you think it'll be in 10 years? We don't know. Well, it'll probably be double what it is in 10 years, and we need to plan accordingly. So my favorite estate planning arrangements have thought in advance. Okay, now, almost all of my estate plans for a married couple involve one or more revocable trusts to avoid probate and to have a landing place for assets, also known as a receptacle, not a reciprocal, as I almost said. So, spouse one has a revocable trust, spouse two has a revocable trust, and if they're in Florida, we typically don't put anything in that trust because if somebody sues spouse one, they can reach what's in his trust. And if they sue spouse two, they can reach what's in his trust. So most Floridian clients have a lot of their assets in a tenancy by the entirety status, either by direct ownership as tenants by the entireties, or under an LLC that can be owned as tenants by the entireties. So if one spouse gets sued, they don't lose the assets. Now, if the clients are older, like in their 70s, less likely of being sued, more likely to die, then it might be appropriate to fund these trusts. So when spouse one dies, if there's joint assets, spouse two can disclaim up to half of the joint assets. So they pass by pour over will into spouse one's amazing family trust right there. That's where it ends up. It benefits spouse number two and is never subject to federal estate tax or creditor claims or divorce claims that spouse number two runs into. And as I met yesterday with a surviving spouse, and it's never pleasant to lose your spouse if you liked them. And this particular surviving spouse did like her spouse who she lost. And I explained that what's in the revocable trust is very well protected, and it consists of 3 pieces of real estate. But what was joint is now belonging to her. She could disclaim up to half of these joint assets to the first dying spouse's trust, but then she would not have a power to direct how those disclaimed assets or their proceeds would pass on her subsequent death. So that is a decision to be made. Now, in addition to having revocable trusts, each spouse will typically have an irrevocable trust if they are trying to reduce federal estate tax or they are trying to enhance their creditor protection. And we'll go to slide 25 and show you that. My favorite estate plans will have the clients owning most of their valuable assets under LLCs. Now, not IRAs, not pensions, not annuities, which you usually don't need and shouldn't have, but stocks, bonds, and real estate, I like to put under an LLC. Why? Because I like to form LLCs. That's what we get paid for. That's the only reason. Actually, there's other reasons. One reason is I'm always concerned that this couple may forget or make a mistake in placing their assets jointly under tenancy by the entireties. So if I form an LLC, own 97% as tenants by the entireties, they put the assets under the LLC, I don't have to worry about that. Secondly, if that LLC is owned, for example, 3% by a trust for their adorable children, or their adorable grandchildren, or their parents, then if somebody gets a judgment against both spouses, or one spouse dies and the other spouse has a judgment against him or her, in most states, the LLC will have what we call charging order protection, whereby if I own a piece of property, you get a judgment against me, you come and get the property away from me. On the other hand, if I own property under an LLC and my daughter owns 3% of the LLC, you get a judgment against me. Under Florida law, Delaware law, New York law, many laws, the sole remedy of a judgment creditor is to get an order from the court saying if and when you ever make a distribution from the LLC, you have to pay the creditor. Well, the judge can't make me make a distribution. The creditor can't make me make a distribution. So now I have a charging order against me, and the LLC, to keep the assets in it, can't distribute anything to me, but that plaintiff lawyer who gets that judgment against me is very likely to tell her clients, hey, let's just get this thing settled. Otherwise, he's never going to make a distribution. We're never going to see any money. And I want my 33 1/3%. So it's not only a record speed, it's a common shared percentage of what the plaintiff lawyer gets if they settle before trial. If they settle after a lawsuit is filed, they typically get 40%. So my client gets the notice in the mail from the plaintiff lawyer, and my client says, oh, we're sorry. We don't think we're going to lose the lawsuit, but even if we do, all you're going to get is a charging order. I mean, we're sorry that the dog ran in front of the motorcycle and it was a sad situation, and we've had those situations. There's a really good Florida case on it, on that exact situation. The pit bull somehow gets outside, jumps on the motorcycle motorcycle driver is killed. Tragically, the pit bull is also killed, and the people, because they allegedly violated the law letting the pit bull out, could lose their homestead in Florida if letting the pit bull out was a crime. So don't buy a pit bull, and keep your assets under LLCs, partly owned by others, so you'll have charging order protection. Now, what if you live in Colorado or California where they don't have charging order protection? Well, if that's the case, set up a Florida or Delaware or Wyoming LLC where we have tenancy by the entireties and charging order protection. And even though you're in California or Colorado, you may still get charging order protection and tenancy by the entireties protection. The law is not clear. There is an Iowa Supreme Court case, and as I've said before, Iowa is one of the top 51 Supreme Courts in the United States. And they said Iowa law applies to an Iowa LLC owned by a Florida married couple as to tenancy by the entireties, which it disallowed because it was an Iowa LLC, and charging order protection. So the converse is probably true. Something else that my married couple estate plans normally have for a wealthy married couple or a married couple who wants really good creditor protection is the SLAT, the Spousal Limited Access Trust. With the Spousal Limited Access Trust, spouse one makes a gift, could be from earnings or separate assets, to the SLAT. Spouse two can be the beneficiary. As long as spouse two cannot receive more than what is needed for her health, education, maintenance, and support, the SLAT will be creditor proof under Florida law and the law of most states, and it will not be subject to federal estate tax. So if spouse one puts $2 million in investments in the SLAT, in 10 years, those will be worth $4 million. In 20 years, $8 million. In 30 years, $16 million that will pass estate tax free, even though spouse two can provide half of the family support from that trust. The trust can be disregarded for income tax purposes. It may have to be. So spouse one and spouse two pay the tax on behalf of the trust so it can grow faster. The trust owns an LLC. Spouse one, the control freak, I'm sure you don't know any of those, can be the manager of the LLC, needs to do things on a strictly fiduciary basis. Now, spouse one says, that's not good enough. I want to be added back to this trust if I ever become destitute or divorced. Fine, we'll put the trust in an asset protection jurisdiction such as Nevada, Alaska, or Delaware, South Dakota, wherever you like to vacation. That's a good place to form your spousal limited access trust. There's a lot more information on spousal limited access trusts at our YouTube site. Maybe I'll show you that site towards the end. My favorite estate plan for a single individual, there will be a revocable trust, but it typically will not be funded. And I want, again, charging order protection as best I can. So some show and tell, some things we've done or talked about doing with real life clients in the last week to 10 days. This is a client who has used his entire exemption, but is heck bent on getting a $10 million condominium to his son, and was going to actually gift the condominium and pay $4 million in gift taxes. Then we talked about putting the condominium into an LLC and gifting 99% of the LLC to the son, maybe value that at a $6.5 million gift because of discounts, pay a gift tax of about $2.7 million. Remember, when you do that, if you live 3 years after you make the gift, the $2.7 million is also out of the estate, so the family comes out ahead, assuming the estate tax doesn't go away, but no one wants to do that. So what about if the client makes a $650,000 seed capital gift to this irrevocable trust, and then puts the condo in the LLC, waits about a month to see if he still likes the son after a month, make sure he pays my invoice. Then we do step 2. We have the irrevocable trust set up with the seed capital gift, and the client sells the condominium unit. Sells the 99% non-voting member interest in the LLC to the irrevocable trust for a $6.5 million note, bearing interest at 1.9% over the life expectancy of the client, which is about 25 years. We've locked in the low interest rate. The client's estate will now only grow by $123,500 per year. To avoid what's called the Powell case, the Strange case in Internal Revenue Code section 2036, little a in parens, 2 in parens, we set up a trust for those adorable grandchildren, and it owns a 0.1% ownership interest in the LLC. The client gifts the grandchild trust $11,000. The grandchild trust contributes $10,000 to the LLC in exchange for its 0.1% interest. So at a gift cost of $650,000, we've gotten most of the future growth of a $10 million condo out of the client's name. Now, the son can lease the condo on a 98-year lease. The lease may still be terminable upon various events. That should qualify the property for the Florida homestead tax exemption. So now, if the client does not want to pay gift tax on $650,000, he could get married, and then to somebody who's willing to split that gift. So then he's only made a $325,000 gift and pay gift tax on that if he's above the exemption. Or he could make a much smaller gift and have another entity that he sets up guarantee the note to make it fairly safe. So that is one of my favorite plans. If we do it, haven't heard back from the client yet, but I did write the client a letter about it, a letter to his other advisor, which you have here, and you can read. And then I cited a couple of YouTube sites where you can go about and read about family installment sale planning, and the Biden two-step, which is also something that I'll be discussing soon. So when a married couple comes to me for estate planning, and assuming that after the conference they intend to stay married, we talk about how to place their assets. And often they'll come to me where everything is 1/2 in each spouse's name, and I explain the creditor issues, or everything is in one spouse's name, and I explain the creditor issues and the estate tax issues. So assuming that Fred in this PowerPoint is a neurosurgeon and Wilma is a soccer coach, then I'd like to have Fred own basically nothing, but he could own tenancy by the entirety's assets. But then if Wilma dies first, he's out of luck. So if he likes her, of course. So then he would own those joint assets. So a common balancing act here is to set up a holding LLC, typically in Florida or Wyoming. Wyoming has good confidentiality features. Florida has good everything but confidentiality features, and Delaware is very good too for this. So I'm going to do an irrevocable trust for their children, which may also benefit Wilma if Fred funds it, to own 20% of this LLC, to keep it 20% of the LLC out of their estate for estate tax purposes. I'm going to have 40% owned by Wilma. So Wilma's revocable trust will own it to avoid probate. Now, if Wilma dies first, 60% is protected from creditors. Fred has 40%, and then Fred's 40% would be protected by charging order protection. So that would be more common of what a client would walk out of our office with versus what they walk into our office with. And that is explained in slides 35 through 37. Now, from the Affluent Floridian presentation that I gave on November 20, which is also on our website, just don't forget asset protection. It is very important, and my favorite estate plans all allow somebody like Fred to file a Chapter 7 bankruptcy and have nothing that he will lose. That's not always possible. If Fred owns a medical practice, then I will have the medical practice to the extent possible. If there's an office building, I'll put that into an LLC owned by Wilma or TBE or some combination. And then I'll have them borrow a lot of money on the building and give the medical practice assets as additional collateral for the loan. That provides pretty good coverage. Malpractice plaintiff lawyers will usually settle at limits if there's a big lien against the practice assets, even though they might be told by their advisors that in bankruptcy they might be able to recover something. They usually want to take the policy limits and run if there's nothing else exposed. So when you do this estate planning, the question needs to be, if somebody sues me, what can I lose? If somebody sues my spouse, what can I lose? If my spouse dies first, what happens? If I die first, what happens? If we both die in a common accident, what happens? Those things need to be addressed, and hopefully they are. Now, I ran into two situations this week with clients who are fairly high risk and have more than half an acre within the city limits of their homestead. So with both of these clients, we are talking about hiring the surveyor to come back and survey out the least valuable portion of this so that it's back down to half an acre, so that the client cannot be forced into a sale. Under Florida law, if I own half an acre or less and I'm within the city limits, you cannot force a sale of my homestead. You can't touch my homestead, even if I made a transfer of cold and legitimate money into the homestead at the last minute after the judgment. You can't set it aside under Florida law unless you can find a way to force me into bankruptcy. So if you're over half an acre, you may need to get creative and cut that up. It does often happen. So let me see here. I brought some other slides. This one's too small to see. Let me see if I can find it here. I believe it was there. No, it wasn't. Okay, let me see if I can open this up for you. So this is a married couple. You see a lot of assets jointly as tenants by the entireties, but not all of them, because if things don't go well, I want them to have enough in tenancy by the entireties, but not too much. And then you may have assets by a previous marriage that they don't want to share, and maybe there's plenty of debt on those assets or part ownership of LLCs. with an irrevocable trust. And then here, some estate tax and creditor protection planning. You see a holding LLC, which owns investments. And then you see a separate holding LLC, which in turn owns LLCs, which own properties. And then you see that we have valued these subsidiary LLCs, and we have turned the investment LLC into voting and non-voting interests, and we have had the clients sell a big part of the LLC to a trust for descendants in exchange for 2 promissory notes. They're both red, not because they're embarrassed, but because we always show promissory notes on our charts as red. And one promissory note is bearing interest at about 1.8% because it was put into place this year, and it is not self-canceling. It will go for 25 years. But the other note is the rest of the sales amount, and it is self-canceling, so it's bearing interest at a higher rate. I think this client was about 65. I think the interest rate is about 7%. And if this client dies, the note goes away, and the client will have no federal estate tax. So then you've got a grandchild trust, which owns 1/10 of 1% that we see there. And then you've got the children. Now, this client, unfortunately, made large gifts of LLC interests to children directly. That is my least favorite estate plan. I had 2 conferences in the last 10 days. One, the child's getting divorced, and it's too bad that the parents put a couple $1 million of a partnership in the client's name years ago, because now all of that is getting scrutinized by his spouse's lawyer. If it had been in a protective trust, it would be much less appealing and much and less available. And then with another client, unfortunately, the child died. The client does not get along with the child's spouse. The child's spouse inherited the limited partnership interest and is using that and the grandchildren as leverage to get a better economic situation. It's going to get even worse if she remarries, I believe. So all of our estate planning, nothing goes to the children. Even when we represent the children, we go to the parents. Please don't leave us anything. No, 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 no. Leave it to a trust that can benefit us without being subject to federal estate tax. And oops, stage here. Let me go back to slideshow from the beginning, and then I hit display schedules, swap, drop, and here we go. Going back to where we once belonged, just like the Let It Be album, which I'm really enjoying. Okay, here's another favorite, which we've just been working on, but it's not untypical. This client has, if you look below his living trust, he's got a Florida homestead worth $280,000. He's got a New Mexico home that he spends a lot of time in worth $800,000, and 7 investment properties in Florida, down up in the Panhandle. 11 New Mexico investment properties. That's most of his estate. We summarize on the left that his net worth is about $11.6 million, including real estate of $6.7 million. He's in his early 80s, very, very healthy, expects to live a long time. One parent made it to 100. So he's used $2.6 million of his exemption. Now, my favorite estate planning event has everything on one page just like this. So bless our secretaries who are able to go through the client's information, go to the public records, look for LLCs and companies, look for deeds, correct what the client's misperceptions are on ownership, and allow me to start a meeting with this chart. And then we move to this chart. So what did I do? I put the investments of about $1,580,000, mostly equities, into one LLC there. and then the New Mexico Real Estate and another LLC. Now, I recommended 4 New Mexico LLCs. The client said, no way, not doing 4. I'll just do 1 and I'll risk it. Okay. Then 1 Florida LLC. And by what I mean, I'll risk it is if one of these properties gets in a big lawsuit, you could lose all of them. So I'd rather see this LLC be a holding company and own 4 separate LLCs, which can each own two properties. But in any event, we set up an irrevocable trust for the children and grandchildren. He will make a $700,000 gift of bonds to this trust. And then these LLCs, which are worth about $8 million, he'll sell the 99% non-voting member interest to the trust for the children for a $5,700,000 promissory note. And that note will bear interest at 1.9% if we can get it done this month, which I don't think we will. Maybe next month. The rate will probably be a little bit higher next month. And now the net worth, if you see here, is down to $8,544,000. That assumes that the note would be valued at $5.7 million on death. Because it's a long-term note, it's probably worth 80% of $5.7 million. It's probably worth $4.5 million. So on death, we would not have to file a 706 estate tax return, even though the IRS may disagree with the discounts that we've used. They are conventional, and there is case law on the discounting of a promissory note. So this takes the client from estate taxable to non-estate taxable. And even though the client will not spend the whole $109,000 a year, he spit out about $150 a year of positive cash flow, but the client will use the $109 a year to pay the income tax. So actually, the client may have to receive principal every year for cash flow purposes, which is fine. That will further reduce the value of his estate. Now, for the properties he lives in, we'll do 8-year Cuperts. I proposed 8 years because I like to use an age where the person has about an 80% chance of living that amount of time. The client is so healthy, we think he will. We could go shorter, but it's going to be his decision. But the key is, if we go with an 8-year Cupert, a $280,000 home going into an 8-year Cupert is a gift of only $127,000, and an $800,000 Mexican home, a New Mexico home going into a Cupert, is a gift of only $363,000. So if he lives the 8 years, those will be out of his estate. He is not concerned about creditor protection, but I would still like to see this note in about 6 to 8 months after we do this transaction, when he is ready to do more planning and not sick and tired of me for a few months. We may put that note in a separate LLC owned partly by his children and partly by him, so that if he gets dementia, nobody's going to snag that note, or if he backs over somebody on the Publix parking lot, nobody's going to sue and get that note. They would only get a charging order. And then when he dies, there may coincidentally, not by intention, of course, be even a bigger discount. Now, one thing we've been doing that we weren't doing 3 months ago is we go ahead and just plug in the client's pension and IRA account amounts and show the client, okay, based on your age and based upon the assets in these accounts not even growing, here's what has to be pulled out every year. So if you think you can't live on Social Security and the promissory note, let's keep this in mind. And we just show them the numbers, because some clients think it has to come out of the pension plan so fast right away. Not really. It comes out pretty slowly, and if it'll grow at 6 or 7%, there'll still be a lot in there at age 100. But the minimum distributions is just something that the clients like to see. So here is our Cupert chart. And for those of you who have seen it before, Brandon has supercharged it. So here is an $800,000 house over here on the left-hand side. And for 8 years, he gets to live in it rent-free. So there's no rent going into the Cupert. And then we are showing a gift exemption use of $363,000. So let's go to year 10. In year 10, if the home is growing at 3% a year, then it's worth $1,043,000. And if he's paid rent for 2 years based on 8% a year of the home, he's paid rent there, $81,000 and $83,000. If the rent is reinvested at 7%, he's got $175,000 in the trust that's outside of his estate for estate tax purposes. So the reduction of his estate is $1,229,000. He's only used $363,000 of the exemption. Estate tax savings on death, $342,000. But another thing my favorite estate plans have, intelligent children participation sometimes. The child says, wait a minute, am I going to lose my step up when dad dies? Am I going to have to pay capital gains tax when I sell the house? And the answer, of course, is, I don't know. It is the opinion of me, who is in the minority of advisors, that you do get a step up when the grantor of a trust that is disregarded for income tax purposes dies. So while the IRS may not agree with that, but has not said one way or the other, in fact, they've simply said they're not going to rule on that question if anybody asks them in advance. What if I do lose my step up in basis and the house has a $400,000 income tax basis? So he dies and I sell it for $1,043,000 in year 10. I pay a capital gains tax on 28.8%, which is higher than what it is, but being a pessimist, we want to show a higher percentage. The net estate tax savings is still $157,000. Nobody's going to come and take that house away from the client if he marries or the children. So we think the Cupert is still a nice thing. Now, on this chart, if you want to change the settings, if you want to say, you know, I think that this house is going to grow at 4% a year because it's on the water, okay, just click there. And now it's at 4%. It's rerun all the numbers for you. Now the net estate tax savings is $353,000. And I can also say, well, we think rent should only be 7%. And we think the rent invested will earn 8%. The chart automatically updates. Now, the only thing that the chart does not automatically update is if I wanted to go with a longer Cupert term, say 10 years, then I need to go to Tiger Tables or Number Cruncher and figure out what the gift tax exemption discount is at 9 or 10 years. It won't be that much different than 8 years, but that's the one thing you need to import from Tiger Tables to be able to do this for a Cupert. Now, the other thing these smart children said was, this is all great, you're saving estate tax, but when mom dies, we don't get a step up. Well, again, I think you do get a step up, but if you ask 10 tax lawyers, probably 7 say you don't, 3 say you do. Even if you got the step up, it might be less than 100% because of the non-voting member interests. So what are we going to do? Maybe in 5 or 6 years, we go ahead and sell the voting member interest to the trust for 1% of the value of these LLCs. Or what I explained to the family is, usually, I don't know the statistics, but usually you kind of know before you die. You get sick first. Well, what we could do is we could have a sale agreement in place, not signed, but ready to go. And if she gets really sick, she can buy back some of these houses out of this arrangement by reducing the note. So let's say the note is $5.7 million. She gets sick. We sell her back $5.7 million of the properties or LLC interests. Maybe inside the trust, there's still $6 million left by that time of value. The $5.7 million she buys would be the properties with the lowest basis, and there would be the step up. So by the same token, if she was over the exemption, this note at about 9.5% at her age or his age, and it would disappear on death and there'd be no estate tax. But then if he lives too long, we would have estate tax because of the high payments at 10% to use a self-canceling installment note. So the second thing we do is we draft an addendum to the note, which says this note will become a self-canceling installment note to the extent of blank dollars upon signature by the parties. Now he gets a bad diagnosis, which makes some people happy and some people sad. He's still got more than 2 years to live. We convert the note to self-canceling to the extent needed to zero out estate tax if he dies within 4 years and he only has a 2.5-year life expectancy. So planning ahead with clients who are conscientious and who are educated and check in with you every once in a while is part of the component of a favored estate plan. And how do you get a client to give you all their information and to be patient as you actually charge them to show them the alternatives and to follow through, make a decision and follow through, and then check with you periodically thereafter? How do you do that? Well, one of my favorite people, Mike Markham, says you can't get what you don't ask for. So even though only 40 to 45% of clients probably will handle this, the quest for the estate planner is to find those 40% and not have to work with the bottom 20%, which not give you their information, even gets it wrong and won't let you correct it, wants to know the strategy before you spend 2 or 3 hours or an hour getting to know them and understanding the situation, and then would prefer not to spend $10,000 to save their children $3 million in taxes. You know, this stuff happens. It's part of the whole challenge of being a successful estate and tax lawyer, of helping clients to understand what you're doing, getting the information, and then check around with other people for ideas. I don't know that I would have thought of everything on this chart 10 years ago or 15 years ago. I talked to some friends. I don't share the client's name or specific information, but a lot of times Brandon, Ken, and Chris and I brainstorm. And the challenge that we enjoy is finding a $30 to $40 million estate that we can completely take out of the estate tax system. So I've got a lot of different examples here. This is really favorite and slides that I've probably shown 10 times in the last 15 weeks, but it's important to share this with clients. And when clients come in and they want creditor estate tax planning, they say, well, what should I put into the estate tax planning arrangement? And I say, everything possible. I mean, you own a company that's growing and you own stocks and bonds. Why wouldn't you put all that under one or more LLCs? It's all growing, it's all producing income. And then spouse 1 sets up a spousal limited access trust. Spouse 2 sets up a trust for descendants. You put all these assets under one or more LLCs. You sell non-voting membership interests to these trusts in exchange for low interest notes. And then all the future growth is out of the estate, except for the low interest rate on the note. The clients are paying the income tax on the income of the LLC and the trust. So why would you leave anything out? Why do clients come to us and they've planned for part of the company and they've planned for part of the investments? Why haven't they thrown everything in there to get the discount on all of it and to freeze the growth on all of it? So I wanted to mention another one of our favorite estate plans this year, and Brandon can take you through the math, was we actually had a client cash in her IRA, or a lot of it, to put in an LLC for a discounted sale because she did not want to pay estate tax, and there was no way to do it without doing an installment sale, both with IRA assets and with variable annuities. But because of the history of the family, and because we were able to use a self-canceling installment note to reduce significant estate tax, but we needed the estate to not have to file a Form 706 on death. So we needed to make the IRA go down and her remaining assets go down below the $12,060,000. So the family bit the bullet, pulled money out of the IRA, paid the income tax, put it in an LLC, sold it for a self-canceling installment note, and the after-tax savings are going to be very significant. It's just something that we had to do. The client was very, very patient, and fortunately, very, very mathematical. So that one worked very well. Now, here is a favorite charitable estate plan with 4 minutes left. And I've shown this before also, but it gives you an idea of what you can do. There was a S corporation, which owned a disregarded LLC, which owned 74% of a company. The company was going to be sold. So about a year before the sale, we valued everything and we sold a discounted interest in the S corporation to a spousal limited access trust and to a descendants trust in exchange for notes. And a year later, what the client dreamed about came true. There was going to be a significant sale. So just before the sale, the LLC made a gift of a large portion of the C corporation to a family foundation. So number one, they got a nice income tax deduction from that donation that happened immediately before there was a binding sale contract. Number two, that portion of the sales price was never subject to income tax because it went to the foundation. And we were able to take a bigger discount at the upper level here on the installment sale by giving the charity a pledge a year early. So in other words, we valued this company lower because there was still a little bit of pie in the sky, but the client promised 20% of this company would be donated to this foundation within 5 years, and that 20% of the dividends from this company would go to this foundation for that 5-year period. Then, based upon that pledge reducing the value of this company, we went ahead and did the installment sales a year before the company sold, and then a week before the company sold, the charitable donation took place at the high side value. Now, the client considered putting the rest of the percentage of the C Corp under a charitable remainder unitrust that would have been owned by the S Corporation. The S Corporation would have gotten unitrust payments, and that would have been a real favorite for me because we love using the NIMCRUT, where you can defer the income tax on the sale of a business or otherwise, typically up to 15 years. It's a deferral, it's not an elimination. So, and you don't have to go to Malta to do it. So that was another favorite. And finally, I just want to make sure that we love planning with S corporations. For some reason, most people don't. So when clients come to us and we're the second, third, or fourth planners, they've done stuff. They've done Cuperts of their houses. They've done securities and LLCs. Why have you done anything with the S corp? Well, you know, I think it just turns out some advisors aren't comfortable gifting part of an S corp, but you can, and you can make what's called an SBID, electing small business company election, and the numbers are insanely good. For example, typical S corp, it makes 10 million a year, and it's worth 6 times earnings, so it's worth 60 million. So 40% of 60 million is 24 million. Take a 1/3 discount, that's 18 million. So it's going to be an $18 million sale of a 40% ownership interest in the S corp. It only needs a $2 million seed capital gift. So you've made a $2 million gift. And look at this. In 5 years, you're receiving $4 million. That's 40% of 10 million. For 5 years goes into the trust, plus the note payments are another 900. The trust has 19 million cash, and it still owns 40% of the stock. So even after the $18 million note, the trust is worth $25 million, and I only use $2 million of my exemption. And the client's paying all the income tax on behalf of this trust. That's why he kept the 60%. I prefer for him to go ahead and gift the 60% too in another way, but that'll be for another webinar. After 10 years, $38 million cash in the trust and a $44 million net worth, assuming the S corp hasn't gone up in value. But now the S corp sells for 100 million, throw another 40 million in there. So planning with the S corps, also big favorites. So we will do my favorite estate plans part 2 in a few weeks. Let me go ahead and remind you of our upcoming, sorry, I forgot how to go to slide 1, so I'm doing it the old-fashioned way. So upcoming, just want to talk about upcoming here. Okay. Next week, estate planning for the business owner, and a continuation of what I did last week, which was business success strategies for businesses and professionals. Then the 29th, I'm very excited. Jerry Hesh is going to join me, and I'm going to listen to him because he does most of the talking. And we're going to talk about the mathematics of estate planning. If you like math or you like Jerry, don't miss that one. Then the 5th, we're going to talk about estate planning techniques that our law firm has invented or popularized and how to use them, including the joint exempt step-up trust, the self-canceling note trust, the teapot trust, and some other things. And then February 12th. So we so enjoy giving these talks with you. Enjoy giving these talks for you, and would love to let you for you to let us know what you'd like to hear about. The eye just says the same thing. And we will see you next Saturday at 11 o'clock if you dare.